My name is Patricia Van Haren, and I'm a family law attorney and author of How to File and Survive a Divorce in California. As mediation is a significant portion of my practice, today I'd like to discuss how to have a successful mediation. In some cases, I act as the mediator, and in other matters, I have acted as an attorney consultant for couples who are actively engaged in mediation. In mediation, the goal is to work with your spouse and the mediator to come up with resolutions to the legal issues in your case. Mediation can be comprised of one neutral attorney for both parties or a mediator that works with the represented parties and their attorneys. In many of these cases, the attorneys simply act as consultants to the parties, and the parties work one-on-one directly with the mediator. When the couple has an attorney acting as a consultant, it is helpful to have the spouse sit down with their attorney prior to the mediation session and make a list of objectives and items that they feel are important to be included as part of the settlement. This list may include proposed parenting plans, arrange for spousal support or child support, as well as arrange in time for the duration of spousal support or child support. Mediation is not a place to discuss the emotional issues of the marriage or why the spouses are getting divorced. If there are a lot of emotional issues between the parties, I often recommend that they utilize a therapist to assist them to move past those issues so that we can focus on the legal issues and come up with a stipulated judgment that works for both of the parties. If the parties are seeing a therapist already, either together or separately, it may be a good idea to have a session the day before so that they are in the right mindset to make sound and rational decisions. The goal of mediation is to put the parties in a position of negotiation and compromise rather than an adversarial position, which is seen in litigated matters. Additionally, both spouses should refrain from using fighting words, such as, "let's just have the judge decide," or "see you in court." These phrases are counterproductive to a successful mediation. If you feel yourself becoming agitated, ask the mediator to take a break so that you can recenter and refocus. The key to a successful mediation is to have a negotiation mindset and proceed with the mediation with the intent to resolve the divorce. Both parties should keep an open mind in discussing the possible solutions for settlement and should engage in listening to each other. Sometimes you and your spouse are actually in agreement on a certain issue, but you are not aware of that because you have not been able to actively listen. When conducting a mediation, I like to first focus on the agreements the couple has already made with each other. For example, they may have an agreement that they will share custody, but they don't yet agree on what that looks like. The mediator can present different parenting plans, but starting from a point of agreement and brainstorming with that couple. It is also helpful when clients communicate with each other about how they want to handle a difficult decision and set goals so that when they come to the mediation session, it's easy to navigate the next step needed to resolve their divorce. Prior to the time that either spouse signs the final judgment, they will be given the opportunity to review it with their own attorney. If you have questions about what is in your agreement, the time to ask your attorney is before you sign the judgment. You want to make sure that you fully understand all the provisions in your divorce judgment before you sign it. Your mediator should help you navigate the legal issues of divorce and assist you and your spouse to find reasonable solutions that are in accordance with California law. If you have any questions or want additional information on email, feel free to email me or give me a call.